Good morning, everybody. I'm Burt Garland, a shareholder at Ogletree Deacons, and welcome to This Week at Work.
This Week at Work is the only show about the workplace that offers you front row seats and a microphone featuring experts in human resources and employment law to bring you practical, timely, and accurate insights so you can more effectively lead your organization. It's Thursday, October 10th, episode 299. Today, election season is here and the stakes are high, not just for our country, but for the future of your workplace. How will the results impact labor laws, employment policies, and your business operations? We'll explore the potential shifts in legislation, the latest trends you need to be aware of, and how both employers and employees can prepare for what's next. Whether you're concerned about wage laws, worker protections, or corporate regulations, we've got the expert analysis you need because we have Burt and special guest Jim Plunkett, live from Washington, D.C. All this and more on This Week at Work.
Good morning, everyone. It is a very excited time for me, and I know it is for our special guest, who I'll introduce in just a moment. But this show, of course, is for you, our viewers and listeners, and I hope to offer a productive lens as we look into how the election, which really is about 4 weeks away from now, might shape the workplace. So with that in mind, I'd like to introduce our wingtips on the ground in Washington, D.C., my friend, my colleague, our man on the ground in D.C., Jim Plunkett. Jim, what lens are you looking through when observing the grasp for power in a short month away?
Sure. Well, thanks again for having me, Burt, and it's good to see you. So it's busy season for me, right? I feel a little bit like an accountant on April 14th, and I got 30 more days to go. But yeah, it is really wild. Sort of trying to figure out what's going to happen, right? I'll feel much better after the election, assuming that we have a decision, right? I mean, that's something to contemplate, is that we might not know for a couple of days who's going to win or who might win the Senate or the House. But we'll do our best, and hopefully we have some time this morning, Burt, to get into this and to sort of look into the crystal ball and predict a little bit for our attendees what different policy landscapes might look like depending on who wins. But then maybe after the election, I'll come back and we'll have a little bit more concrete info that we can present to our attendees.
That sounds great, Jim. So with that in mind, let's move forward here real quickly, because I know the viewers are excited to hear what you have to say substantively. So let's go ahead real quickly. We'll introduce the poll as we encourage your thoughts and feedback. And today we have two questions for you. So the first one is, do you think election results are trending towards, I'm not going to ask about which candidate, but do you think election results are trending towards having more or less influence on labor and employment? And there's a draggable scale that we'll show you there. And I bet Jim and I will have a little bit to say about that. And then the next one is, what is the biggest concern you have about how November's election may affect your department or your company? And that's an open-ended question for our viewers. So two questions for you. Would love to get your thoughts on that, hear what you have to say, and hopefully we'll have a chance to get to those poll results a little bit later, and Jim and I can chat about those. So with that in mind, I think we'll ask people to share their thoughts on that. And I think I'm ready for Lawyer on the Clock, Nick.
Let's do it. All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right. Thank you there, Nick, for that quick introduction. So I'm going to spend a little bit of time talking about the EEOC today, because the EEOC just last week crossed into its new fiscal year. And so interestingly, right as they were about to end the last fiscal year, they filed a slew of new lawsuits before the fiscal year wrapped up last week. Even though it brought fewer cases than it did the prior year, it shows that the agency is focusing on potentially high impact systemic suits and targeting key priorities. that they believe should that merit additional enforcement. And it's interesting because with the possibility of the change in the White House, which means that there will be changes at the EEOC if Trump wins. I think things will continue largely as is if Harris wins. The EEOC, I think, recognizing that there could be a change of power, filed these lawsuits, and that means that well into a Trump presidency, if there is one, that the EEOC will have plenty of litigation to keep itself busy with. And so I think strategically, it's consistent with years past or administrations past where they throw a lot of these lawsuits out there, and it will mean that they have plenty of litigation moving forward. Now, interestingly, at the EEOC, because of the way the staggered terms work, right now there are only 4 EEOC commissioners serving on the commission in Washington, D.C. There are 3 Democrat members and 1 Republican member. And I doubt, and Jim, I'd be interested in your thoughts on this, I sort of doubt that before the presidential election coming up in a few weeks here, that second Republican member will get confirmed by Congress. What are your thoughts on that?
Yeah, I agree with you, Burt. There's not even a nominee out there. They're just going to let it run, with 3-1 Democrats and see if they can preserve that as long as they can.
Yeah, so that's exactly right. And what that really means is that if Harris gets in or Trump gets in, I think shortly after an election, you will see a second Republican commissioner appointed. But what really is going to happen here, and this is no different than when Biden took over from Trump, is that if Trump takes over for Biden, the EEOC is still going to have 3 Democrat commissioners for about a year to a year and a half into a Trump presidency. And so I think things will be interesting because what happened during the Biden administration is that even though the Republicans held a majority of the seats on the commission, the Biden administration took the then existing chair of the commission, and even though she was from the majority party, they demoted her from chair and appointed somebody from the prior minority party to be chair of the commission, even though that chair had fewer seats on the commission. So very strategic how things will shake out here. I do think that, again, if Trump wins or Harris wins, you will see that second Republican commissioner appointed, but it is going to be a 3-2 Democrat majority for at least a year to a year and a half into the next presidency. So,
hey, Bert,
turning back now, yeah, go ahead, Jim.
Just one thing for folks to be on the lookout, just because of what you said about those staggered terms, that they are going to have a majority no matter who wins for some time. Employers and our attendees tuning in this morning need to be on the lookout for a regulation that I expect that they will try to finalize that will require employers to submit to the EEOC what they're paying their employees. Right. This is they are desperate to get your pay data, your salary data, your hours worked data. And the EEOC has forecasted on the regulatory agenda that they're going to propose a rule that would require employers to do that. We don't know the details of that, but suffice it to say it will be expensive, invasive, and set employers up for discrimination claims and potentially union organizing. So be on the lookout for that.
Our viewers definitely appreciate that insight, Jim. So turning back to these lawsuits that the EEOC filed. So in fiscal year 2024, the EEOC filed its first lawsuits alleging violations of the Pregnant Workers Fairness Act. We'll talk about that in just a minute. So the latest EEOC strategic enforcement plan, which was passed a little over a year ago, that runs through 2028, and that included commitments by the Commission to protect vulnerable workers who may not know their legal rights or are uneasy about exercising them, and consistent with prior administrations to combat systemic workplace discrimination and harassment. So one of the sectors, and we've talked a lot about this on the program because I think this seems to be sort of certainly under the Biden administration, and prior to that, Obama administration. Then you saw things go the opposite way during the Trump administration. The retail in service industry sectors, in the health sector, so hospitality, research, retail, restaurant, healthcare, those industries have literally been under assault by the federal government. And so is a lot of an interesting aspect of the EEOC's new cases that it filed in fiscal 2024 were in those areas of restaurant, retail, hospitality, and the healthcare sectors. And so I think when you have industries where there's a lot of turnover, a lot of interesting things go on with wages, with tip minimum wage. You might have teenagers sometimes working in those industries, and you might see workplace harassment claims coming out of that. So I think that if you're in those types of industries, if you're an HR practitioner in one of those companies or the general counsel in one of those companies, you really need to keep your eye on your harassment, discrimination type policies in those industries. Also, I mentioned that the EEOC really is focused on this Pregnant Workers Fairness Act. They filed 5 lawsuits in fiscal 2024. The first of those lawsuits was against a trucking equipment manufacturer that put a worker on unpaid leave instead of trying to accommodate her pregnancy. The last of those Pregnant Worker Fairness Act suits was against a Florida resort that allegedly fired a line cook rather than consider her request for 6 weeks of leave to physically recuperate and grieve following a stillbirth. So very interesting cases going on. And because of the timing of the filing of these suits and the makeup of the EEOC with those staggered terms, I think even if President Trump were to regain the White House and appoint a new chair to the EEOC, this litigation will continue. You have a commission that will support these efforts. So one interesting aspect of all of this is it's not going to end even if the White House changes. Sticking with the EEOC, before we get to Jim real quickly, maybe taking a look at a lighter side of things. I don't know why I like to pick on the dispensary industry, but a Colorado marijuana dispensary has agreed to settle with the EEOC a lawsuit claiming it fired a worker for failing to clock in and out of her shifts, even though she informed supervisors that she had memory issues due to her disabilities. So this one had an employer kind of in a catch-22. So the EEOC and Nature's Herbs and Wellness Center, which does business as High Plains Strains, asked the federal judge in Colorado to approve a consent decree. In that consent decree, the dispensary will pay $95,000 to settle the case, and on top of the payout, the owners have to send an apology to the former employee. And the apology language has been put in the consent decree. It says, on behalf of Nature's Herbs, Inc., I wish to express my sincere regret how you were treated during your employment with Nature's Herbs. We will review our policies to ensure they explain the process for employees to request an accommodation. So this employee had been working for this company as a bud tender at one of its shops in Colorado in October 2019. During her interview and throughout her employment, she told her supervisors that her disabilities impacted her memory and she might have trouble remembering things such as how to clock in and out. And so now, like I said before, it kind of put the employer in a catch-22 because, of course, if you have an employee who's not clocking in and out properly, well, then the DOL is going to come down, sniffing down your throats and trying to figure out if you're not paying the employee correctly. And so this employer gave her some performance reviews, encouraged her to improve her memorizing of pricing of the products, and also to clock in and clock out properly. She eventually got a verbal warning for that. And she told the manager that she felt the warning amounted to disability discrimination because of her memory issues. She eventually got terminated for failing to clock in and clock out properly. And she filed a charge of discrimination with the EEOC. And again, this is settling. So I think it just shows that employers, again, there are more employers, I think, that get nailed for failing to engage in the interactive process with employees than they do for actually terminating employees who may or may not have a disability. And here, I don't think the employer really engaged in that interactive process to try to figure out if it could reasonably accommodate her. And rather than continuing the litigation, the company decided that it was better off settling the suit. So High Plains Strains is going to be out of this litigation. And I think, again, the case serves as a reminder that employers really do need to balance interests, pay aspects, Department of Labor compliance, EEOC compliance, and don't forget to engage in that interactive process with the employees.
Hey, Burt, is it true that the employer wrote the apology note on rolling papers?
Jim, I'm not quite sure of that, but I can dig into that a little bit further. They may have.
Ooh, I
All
got
right.
one
Well,
too.
with that in mind, I think that makes a good time for us to transition over to our discussion with Jim in the Employers Lounge here. And we're going to talk today about ballots in business, labor and employment impacts pre and post vote. So with that in mind, Jim, why don't you give just a kind of a quick introduction of how you think things are going to shake out over the next few weeks here running up to the election, and then depending on who wins the election, and like you said, crazily enough, we may not know for a few days, just like the last election, some way, somehow.
Right.
And what do you see when you look into this crystal ball?
So first, I would say, Burt, is that it's an unusual situation for a couple of reasons. First, we've got the incumbent roles are are a little jumbled up this time around, right? Like Harris is sort of the incumbent, I guess, right? But then also Trump is in a way, as a former president, sort of the incumbent. So and that usually is a pretty bright line dynamic. You've got the incumbent and the challenger. This one, it makes it a little wacky. There's also the role of
I think that's the term of the day, a little wacky.
a little wacky, yeah. There's also like the role of organized labor here, right? You've got the Teamsters who famously have withheld their support for Harris because of the rank and file support for Trump. And Trump as the Republican, he's a Northeast guy, and he's a developer, and so he has these relationships with unions, and in the hospitality industry as well. And in Atlantic City, had these relationships with unions. His first term, though, showed that I think where he sort of curries favor with unions is through trade policy and that sort of thing. And he, at least in his first term, he tended to sort of toe the traditional Republican line on labor and employment policy. And if he wins, though, I think that there's some things that, given his sort of populist bent, right, and how some of the Republicans are moving towards that populist view, including his running mate J.D. Vance. You've got Josh Hawley in the Senate,
right here from Missouri, by the way.
For sure, and some of the issues that you all talk about on the program might be a little bit tricky for Trump to deal with. So, for example, things like the Fair Labor Standards Act independent contractor regulation, I think he would go through the process to get rid of that, right? The OSHA walk-around regulation that allows third parties to come in, so union organizers to accompany OSHA inspectors, or the Sierra Club to accompany OSHA inspectors, or your competitor to accompany OSHA inspectors. I think that one he could get rid of pretty easily too. But something like the overtime, right, which is perceived publicly and colloquially as giving employees a raise, even though when we know that that's not the case, just makes some more eligible for overtime, doesn't mean they're going to get that overtime. Getting rid of that might be politically tricky for him to do, right? So if that survives the current legal challenges, I'll be interested to see what they do with that, because I would not say that that's a guarantee that he's going to try to strip that off the books. Same thing with the Federal Trade Commission's ban on non-compete agreements. Again, if that, that's tied up in court, and it could take a while to resolve that. But if that survives, I don't think it would be automatically revoked by a Trump administration, because there is this bipartisan skepticism of non-competes, and you even had some populist Republicans file amicus briefs in these legal cases on behalf of the FTC. So you had Republicans defending the FTC's policy on their non-compete regulation, which is really interesting. So those are sort of the thing, the issues that he's going to have to deal with. So it's not always going to be black and white. I think in a Harris administration, Burt, she is going to, try to, President Biden has said, hey, I'm the most pro-union president that we've ever had. And I probably tend to agree with him. I'm a little bit concerned about recency bias, but because we've had some pretty pro-Republican presidents. But he's really taken what he calls the whole of government approach to promoting unionization. So it's not just the NLRB and the DOL and the EEOC, but agencies like the EPA and the Department of Energy. If they're handing out grants, you got to have prevailing wages, you got to have apprenticeship, you got to have neutrality agreements, you got to have labor harmony agreements, right? He's dotting all of his policy priorities with goodies for organized labor. So I think Harris is going to try to pick up that baton, right? Where she might try to distinguish herself or carve out her own path, I think are on, we touched on this earlier, like things like pay equity, right? And as a candidate, when she was briefly a presidential candidate, she proposed that employers obtain an equal pay certificate from the Department of Labor, which would require employers to go through this audit process and get it blessed by the Department of Labor. And if they didn't do that, they would be subject to significant fines. And as a presidential candidate, she said, if I can't get this through Congress, I will do it administratively, which means if you're a federal contractor, she would try to impose this via executive order. I also think something like a topic like paid leave.
Well, hold on one second there. So again, Jim, she would try to do that through executive order for federal contractors, but she'll also try to do it in the private sector through the administrative agencies themselves, through the appointments and rulemaking, correct?
Yes, if they're there's some court decisions, the Loper-Bright decision that I talked about the last time I was on, that might help the employer community attack those efforts. If they're perceived as the agencies going beyond the authority granted to them by Congress.
Right.
But yes, I do think she'll be using the bully pulpit to talk about pay equity and paid leave. And then her constituents are going to want some action from that, right?
Sure.
And she'll try Congress first, and depending on how that shakes out, she may or may not be successful. But then if she keeps pounding that drum, at some point she's going to have to try to do something about it. And I think that's where she would go to the agencies to try to do that. But yeah, like paid leave, she can't do anything executively or with executive order. But I would bet quite a bit of money that if she's president in the first 2 weeks, there will be an executive order that's very sort of aspirational in nature, sort of saying like, hey, my administration supports paid leave for all these great reasons, and I'm going to encourage these private-public partnerships to develop paid leave, blah, blah, blah. It won't do anything require employers to do anything, but it'll sort of set the tone of one of her policy priorities, I think.
Yeah, and I think what's really interesting is we've talked about this on the program many times. Most employers in the U.S., most, not all, but most employers in the U.S. do provide various forms of paid leave for their employees. Now, interestingly, and I touched on this at the beginning of the program, is that where you do not see a lot of paid leave is the restaurant, retail, hospitality sector. Those are a lot of times tip minimum wage employees. You don't work, you don't get paid. You can usually take the time off. Not always, but you can usually take the time off. And if you take the time off, you're just not going to get paid. And I think that that sort of gets to what I was saying before, Jim, that's kind of the administration taking the whole of government approach to try to make sweeping changes in the restaurant, retail, hospitality sector.
Right. It could be an interesting discussion too, Burt, because employers with a national footprint, I think, have grown tired of dealing with the patchwork of paid family leave laws. And so there could be some interest from Republicans and the business community to at least engage in conversations about a potential national framework. They would obviously need preemption to preempt those state and local laws. But it could present an interesting dynamic.
Yeah, and we've got one of our favorite listeners out here, Dave Forsey. And so I think that what Dave is raising is, do you expect if Harris wins that employment law is going to become more onerous than it is today?
Yeah, I think, yeah, she will continue to, make things a little bit more difficult for employers under the guise of helping employees, whether it's helping, making it easier for them to organize, some sort of like a paid leave, prohibitions on inquiries about past pay history, and the people that she appoints, right? And then, the thing is, these days with Congress not being able to really do anything or agree on anything, that also sends a signal. Even if Congress is not going to pass a law, that sends a signal to the state and local legislators about, hey, what's important? What should we be working on, right? So they see, she's talking about XYZ, well, and she can't get it done on the federal level, but we can get it done here in California or Massachusetts or New York or whatever it is.
All right, well, let's take a quick look at our poll questions here and our poll results here, and let's see if we can get some commentary on that from you, Jim. So do you think the election results are trending towards having more or less influence on labor and employment law? Nick, what's the result of that poll question there?
All right, we are at 3.63 is the average. So we're a little on the more side. Oh, it's going up even as we speak, that it's having more influence.
Okay.
Here, it's trending in that direction. So this is not, and I think to answer Dave's question as well, this is not looking at any particular whether who wins. It's just overall, what kind of influence are elections having on L&E?
Yeah, and I agree with those poll results. I think it is becoming more and more tied to labor and employment policy is becoming more and more tied to the candidate who wins the White House. And you've got that swinging of the pendulum that I would say probably started more. I think, by today's standards, Clinton and Bush, the pendulum didn't swing that dramatically. But I think when we got to the Obama administration, the pendulum started to swing quite a bit more wildly, and that produced a wild swing the other way when Trump got in office, and then of course when Biden got in office, swing back to the left. And I do think that they with the way they've used these administrative agencies has really changed and really does impact labor and employment law. And of course, as Jim mentioned, that Luper-Bright decision may settle that pendulum down, but we probably have about a 5 to 10 year transition period here as the administrative agencies test the bounds of that Supreme Court decision. The cases work their way into the appellate courts and eventually a split in the circuits, and then the Supreme Court refines them. So we're in for a little bit here. All right, so let's look at our next poll question here. And That one, Nick, if you could put that one up.
Nope, that
Do we
was
not
just
have it?
nope. That was more comments and types of
More
things.
comments. All right, we don't have time to get into that one. So, all right. Well, I appreciate you taking those pulling that poll question up there for us, and I know we're up against the 8 o'clock hour. Jim, I want to thank you again for appearing on the program. We're about, like I said, 3 to 4 weeks away from the election. I'd love to have you on the program again in early to mid-November to talk about what happened and what we might expect. And next week, by the way, when we're on at 7:30 a.m. Central Time, that will be our 300th episode of our program. It's going to be jam-packed with stats and other fun ideas. So reward yourself for being a loyal listener and spend some time with us next week on the program. Thank you, Jim. Thank you, Nick, and Feature Group. Now go out there and be good to someone.
Somebody. Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues, forward our invites, share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment. LinkedIn, YouTube, Spotify, Apple Podcasts, we're everywhere you are. Don't forget you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.